there was testimony that it had been examined and tested by the bosun and the mate, and that it was generally around in appearance. After the accident, examination of the rope at the point where it broke showed that it was so rotten as to be inadequate to support the strain imposed upon it. The trial judge concluded from the evidence that there was sound rope on board available for rigging the staging. He found that there was no fault in the manner in which the stage had been rigged, but that the rope selected by the mate was defective and that petitioner's injury was attributable to the negligence of the bosun and the mate in failing to observe the defect. He held that the proceeding was brought too late to recover for the negligence under the Jones Act, and that the ship was not unseaworthy by reason of the defective rope used in rigging the staging. He accordingly denied indemnity to petitioner, but gave judgment in his favor for maintenance and cure. The Court of Appeals for the Third Circuit affirmed by a divided court, resting its decision on the statement quoted from the opinion in the case cited, that the record does not support the suggestion that the ship was unseaworthy. The mate selected a bad rope when good ones were available. We granted certiorari upon a petition which urged that the statement quoted from the cited case does not rule this case, and that the decision below is inconsistent with the decision in the Saccone Vacuum Oil Company versus Smith case. The sole issue presented by the petition for certiorari is that of respondent's liability to indemnify petitioner for the injury suffered by reason of the defective staging. No question is raised with respect to petitioner's right to recover under the Jones Act or his right to the award of maintenance and cure or its adequacy. A finding of seaworthiness is usually a finding of fact. Ordinarily, we do not admit an admiralty more than in other cases, review the concurrent findings of fact of two courts below. Here, however, both courts below have, on the facts found, held as a matter of law that the staging was seaworthy despite its defect. The conclusion of law is reviewable here. Until the enactment of the Jones Act on June 5, 1920, the maritime law afforded no remedy by way of indemnity beyond maintenance and cure for the injury to a seaman caused by the mere negligence of a ship's officer or member of the crew. But the Admiralty ruled that the vessel and owner are liable to indemnify a seaman for injury caused by unseaworthiness of the vessel or its appurtenant appliances and equipment has been the settled law since the court's ruling to that effect in the Luckenbach Steamship Company case. The latter rule seems to have been derived from the seaman's privilege to abandon a ship improperly fitted out, and was generally applied by numerous decisions of the lower federal courts during the last century. This was a recognized departure from the rule of the English law, which allowed no recovery other than maintenance and cure for injuries caused by unseaworthiness, unless the enactment of the Merchant Shipping Act of 1876. By that statute, there is annexed to every contract of service between the owner of a ship or the master and any seaman thereof an obligation that all reasonable means be used to ensure the seaworthiness of the ship before and during the voyage. Okay. Get that? You got the outline for staging?
Yeah, I just put it in. Same with Admiralty.
Admiralty, yeah.
Seaworthy and unseaworthy, and seaworthiness, unseaworthiness.
I do that seaworthy.
C is for me SAE. Then
And then what do you write?
I'm writing worth. I write
No, it says C and then WOERT.
worthy. That's pretty good. I didn't do that.
Fast outline. Do you write Admiralty 2 strokes?
And the maritime.
Well, I write that 3 strokes.
You do? Why not maritime?
Well, yeah, you can do it that way. Just got used to it. Okay, let's call it a day. I'm ready for a nap. That was good. You're getting speed there. See, after a while, no matter how hard the legal opinion and how unusual the language, it's just another take. My Flamel, it was $5.20. It dropped down to $5, and then ended up at $5.15.
The Court of Appeals. Appeals is initial capital.
Yeah.